We turn now to West Virginia, where a former pharmacist accused of killing her husband with insulin returned to court ahead of her murder retrial. Well, back in April of 2023, a judge dismissed a murder charge against Natalie Cochran until her late husband Michael's body could be exhumed and re-examined for a second time. Now, that charge was dismissed without prejudice, meaning prosecutors could refile charges. Court TV's Ted Rowlands catches us up on the case.
Natalie Cochran, a former pharmacist, is accused of poisoning her husband, charged with first-degree murder for allegedly using insulin to kill him.
You are the defendant in this matter, obviously. I mean, you are aware of that.
Yes, sir.
Michael and Natalie Cochran had 2 kids. He was 38 years old when he died. In early February of 2019, he was sick, had a seizure at the couple's home, and then died 5 days later in hospice. Prosecutors say Natalie killed Michael to cover up her $2.5 million fraud.
They're not two separate things that you can unravel and say there's a federal Ponzi scheme and there's a state murder case. They're combined.
7 months after Michael died, Natalie Cochran was charged by the feds for wire fraud and bank fraud as part of a Ponzi scheme. The Cochrans owned a company, Tactical Solutions Group, which they claimed sold weapons to the U.S. Department of Defense. Federal prosecutors alleged it was a fake business. They had no contracts with the government. The millions of dollars investors, who were mostly family and friends, sunk into the company was actually spent on a lavish lifestyle. Cochran pled guilty in 2020. She was sentenced to 11 years in federal prison.
The financial crime gives rise to motive.
The state alleges that Michael had no idea the family business was a sham, and they say Natalie killed him when he became suspicious and started asking too many questions, especially after his parents invested their entire savings and were not getting their money back. During Cochran's sentencing, Michael's mother said she took advantage of us because we loved her and believed everything she said. Lie after lie after lie, and still no deposits were made. The money never came. Cochran's attorney claims that Michael was a part of the scheme.
There's evidence that points to, I'll say that, to the alleged victim's involvement in the case from the get-go.
Natalie Cochran was indicted for Michael's murder in 2021. The case was temporarily dismissed while the state exhumed his body. She was re-indicted in October of 2023. Now she faces up to life in prison if convicted.
The 43-year-old is currently serving an 11-year prison sentence after she pleaded guilty to federal fraud charges. She collected $2.5 million in investments for federal contracts that didn't exist. Well, now in a surprise move, the prosecutor in today's hearing agreed they haven't handed over all of the discovery needed for the defense, and it was a mistake on their part. The judge expressed disappointment about this issue that has been ongoing now for almost 2 years. There have been so many delays in this case. Let's go inside that hearing as both sides make what could be their final arguments 2 weeks before jury selection in the Ponzi Scheme Murder Trial.
They may have everything except what we gave them Friday, or there may be other things missing too, and that is concerning to the state. We want them to have everything they're entitled to, and we, in good faith, thought they did, and we were wrong. And for that, we apologize to the defendants and the defendant. It's a big case. It has a lot of stuff in it, and part of being human is mistakes are made. And in this case, it was a mistake. That goes to the alternative. There is no grounds for dismissal of this case whatsoever. This was a good faith error. We tried to give them everything we were entitled to, and we made a mistake.
There are a lot of unknowns, and we have to nail this down before we can make a value determination. This is the court's observations. This is a difficult case. It involves massive discovery, but it's been pending for over a year. And there was the other case that was pending for a long period of time, and Mr. Victor was was involved in that. Every hearing that I've held in the case assigned to me, I've heard the same complaints. Complaints about discovery, complaints about not being able to open hard drives and open phones. I was assured by the prosecuting attorney, Mr. Hatfield, that all the discovery had been provided to the defense. And it's somewhat irritating and certainly disappointing to find out now that it hasn't been.
Your Honor?
Yes.
Could I have a definitive ruling on my motion to compel as to the things?
Your Honor, the state has not yet responded to the motion to compel.
All right, I'll have to give the state an opportunity to respond.
They have responded, Your Honor.
All right.
Your Honor, we've not been able to present argument as Mr. Selden was able to do today.
Well, let me see if there is any objection to the matters that are requested in the defendant's motion to compel discovery. It seems to me that all this stuff that has been turned over. We're dealing with slides. I understand that the slides cannot simply be handed over to defense counsel, but they would have to be delivered in a protective manner of procedure to the defense expert. And we must live with that. We must deal with that. It just seems that the rest of the material set forth in Mr. Selden's motion have either been provided or perhaps turned over this morning. It seems to me to expedite the process, Dr. Uribe should send the slides directly to the defense expert. At some point, you're going to have to disclose who your experts are, and so it might as well be up front. But frankly, I'm of the belief that we can go forward as scheduled. We have the jury coming in on the 21st and the 22nd, or is it, I'm sorry, it's the 22nd and the 23rd for jury selection. I think we can go forward in that regard and at least get jury selected. And we can go forward. If we have to adjust the trial date a little bit, the court will see what we can do in that regard.
The judge found no intent on the part of the state, so he denied the motion to dismiss and asked the defense to use their investigator to go over the evidence files to make an assessment of what they were missing and how much time they would need to review the evidence before trial. The judge would like to pick a jury on the 22nd and 23rd of this month after he has prospective jurors summoned.